Hello, I'm Christopher Lonn, and I'm an attorney here at Jennings Strouss in Phoenix. I'm going to do a three-part series of videos on the FINRA arbitration process. This is a process that if you have a potential claim or other issues with a stockbroker or investment professional, that you would consider filing. The reason you would file a securities arbitration is because when you open an account with the stock brokerage firm, you will sign account opening documents. One of those documents will include an arbitration agreement. Arbitration is a creature of contract, so therefore when you agree to arbitrate, the contracts in the stock brokerage industry will require that you proceed in front of FINRA. FINRA is an acronym and it stands for the Financial Industry Regulatory Association. This is an association provided for by federal law to regulate the securities industry. The arbitration process is commenced through the filing of a statement of claim. This perhaps is the singular most important document that you would submit in a FINRA arbitration. Why so? Because it is the document that is going to tell your story. So therefore it needs to be crafted carefully with some precision so it has maximum persuasive effect. The reason you want this to be more persuasive than, say, a complaint in a traditional civil court is that the arbitrators, who will ultimately, there will be three of them, there will be a chairperson and there will be two other arbitrators, will look at this document, read this document in advance of pretrial hearings and probably prior to the actual hearing itself. The statement of claim should be as persuasive as possible so that the arbitrators, when they read it in advance of the hearing, are persuaded by the content of the statement of claim. In this way, you've helped yourself enormously because if the arbitration panel is sympathetic to your claims, you stand a greater chance of having success at the hearing. The statement of claim will have to set forth facts and set forth your legal theories, as well as what you are looking for or the damages or other relief you're seeking, and that should be set forth very clearly in the document. A qualified securities attorney is instrumental in this process. Once the statement of claim is filed with FINRA, FINRA then serves it on its member firm or the respondent brokerage firm. Sometimes you will also, as I mentioned before, name the stockbroker, but that's again a strategic decision that should be made with legal counsel. Once served on the member firm, the respondent stock brokerage firm will file their answer and respond to the assertions in the statement of claim within 45 days. Once the pleadings have closed, in other words, once you have a statement of claim and an answer to the statement of claim, discovery will commence. Discovery is a critical portion of this process, and that will be discussed in the next segment.